Welcome to our annual local rules procedure for the United States Bankruptcy Court for the Eastern District of Missouri. We're so pleased you've joined us. We have an excellent presentation for you today about the federal rules of bankruptcy procedure changes, as well as our local rules and local forms. And now I'm going to turn this over to our clerk of court, Dana McQuay. Dana?
All right. Well, hello and welcome to everybody. We are so glad that you're joining us today. And with that, I think we can go ahead and move on to our substantive content. So I'm going to take the very first of the federal rules of bankruptcy procedure to address. And this is something that really is geared towards a national initiative the judiciary has engaged in. The courts hold unclaimed funds on behalf of litigants, people who have either filed a proof of claim and for some reason did not receive their money on time, or whatever the reasoning might be. And so we want to make certain that everyone who possibly could claim has an awareness that they have the ability to do so. So the federal rule has changed to require the clerk of court to provide a searchable section on the court's website to information about unclaimed funds. We in our district have been doing this for a number of years. The vast majority of courts across the country have been doing this. So this won't be a huge lift on December 1 for the court family. But basically, we want to provide access to everyone so that they can learn about a specific case. And indeed, there may be some reason that they had not known even that there was money due and owing to them. If you on this call would like to take a few minutes to do that, you're welcome to go to our court's website. On the homepage, we have a button in the middle of the page. It says unclaimed funds. It brings you to a page where there's a link and you can search. You can put in your name, names of anyone you want, relatives, friends, whoever, and you can do either a search for our court's database, or you can do a nationwide search and you can see if there are funds held somewhere else in another court. It's not difficult to come and claim those funds, but one of the items that is changing this calendar year with the rules change is a form that we use for claiming the funds. And the form really is called, it's Director's Form 1340. It's the application for payment of unclaimed funds. And what the change really is doing is trying to clarify if you are a successor claimant, you hold a claim because you bought it from someone else or it was assigned to you or in some fashion like that, to make it clear. Across the court family, we've had some people who have represented wrongly that they are the rightful owners to funds, when indeed we have done some digging or due diligence, we have found out that they were not. And so this is to help the kind of make it a little more transparent. If you are placing your name and signature under penalty of perjury that you are the rightful claim holder, then you have been identifying yourself as the true successor claimant. Let's hope that's just not ever going to be a case in the future, but we can say that there have been a few of those across the court family, and we want to make sure the money goes to the right person. With that, I think I can turn this over to our judges panel, and I think maybe Judge Walsh.
Sure. So we have a change to Federal Rule 8003 this year. As you may recall, the 8000 rules deal with appeals. And 8003 in particular, the change deals with a situation. I'll just give you a scenario. Imagine that you request a continuance of a trial and it's denied, or you object to the introduction of hearsay evidence and it's overruled. Those aren't appealable at the time, but when final judgment is entered, they become appealable. And so there were a lot of disputes, a lot of them in civil appeals, but some in bankruptcy appeals, about what you need to put in your notice of appeal. Do you need to specify that hearsay ruling, for example, in your notice of appeal? And Rule 8003 has been changed to clarify that no, you do not. And then there's a similar change to Federal Rule of Appellate Procedure 3C, which deals with the same subject matter. So in your notice of appeal, you only need to specify the final order or judgment that makes your case appealable. And that is sufficient to preserve your right to talk about hearsay later on, or to talk about that continuance or something else that was interlocutory and wasn't appealable. There's been a similar change to Official Form 417A, which is the form of the notice of appeal, to simplify the language. So you only need to specify the final judgment or order that you are appealing, to preserve your right to talk about the other things later. Now, it's important to keep in mind that in a bankruptcy appeal, you do have to specify the issues and designate the record, and that's only 14 days later. And if you don't identify your hearsay issue, your continuance, your other interlocutory matter in your statement of issues, you may get in trouble with the district court or the BAP. But the rule clarifies that you don't need to put that in your notice of appeal to preserve the right to appeal it. There's one other change that makes it clear that if for some reason you want to limit your appeal to only a portion of the final judgment, you can expressly do that in your notice of appeal. But the court will not imply that sort of limitation unless you expressly limit yourself in the way that you phrase the notice of appeal. So to be safe, don't do that. Go broad, and then identify your issues later on when you get to the statement of issues and the designation of the record. That's all on Rule 8003, unless there are questions in the chat. We can deal with those later. And I think Judge Surratt States is up next.
All right, I'm going to talk about two rule changes. First, Rule 9006. That is the rule that deals with computing and extending time. And that rule was amended to add Juneteenth as one of the list of legal holidays that can be used when you're calculating time and extending time. So that's pretty straightforward. Then there's also a new rule, Rule 9038, which talks about bankruptcy rule emergencies. So we found during the pandemic that we certainly were able to make some switches and to do some emergency things, but this gives even more flexibility. So it authorizes the bankruptcy judge to extend periods during emergencies, like on a district-wide basis, or if there was something specific to a district or to a particular state. So Subdivision A gives the authority to the Judicial Conference of the United States to declare a bankruptcy rule emergency when it is related, again, to public health or safety, or if it's affecting the physical or electronic access to the bankruptcy court. Subdivision B goes on, though, to give authority to the bankruptcy court itself to declare an emergency when it would be limited to one area of the district or in a particular state or things of that nature. So if there was something that was specific here that happened that affected the Eastern District of Missouri, if there was flooding, a tornado or something, then we would have the authority to put an emergency in place and extend deadlines. Subsection C also grants authority during a declared emergency to extend or toll deadlines on a district, division-wide, or in specific cases. So again, just giving more flexibility when emergencies come up. We're not anticipating anything else coming up, certainly like the pandemic, although I think that we certainly handled that very well, but this will definitely give us more flexibility going forward with that. Then I think now, Mr. Rodman, I'm going to turn it over to you to talk about some official form changes.
Thank you, Judge. Just want to make everyone aware of one additional official form change. Judge Walsh talked about the change to 417A, and the clerk had spoke about the change to Form 1340. There's been a very small minor change to Form 410. This is the mortgage proof of claim attachment. The only change there is that in Part 3 of this form, there has been a separation of, or itemization rather, of principal due and interest due. So it just separates those two things out to make it a little bit more clear for the person filling it out or the person that may be reviewing that proof of claim attachment. Very minor change, but that will also go into effect on December 1, 2023, here in a few weeks, just like all these other federal rules we spoke of.
And Matthew, where would attorneys find those forms?
So you'd find those forms on the U.S. Court's website. If you, at the very top of this training document that we had put together, we have some links here to our rules and procedures page as a local court, but also to the U.S. Court's website. Until December 1, all of these changes and the forms that we had just spoke about will be on this link to pending rules and form amendments.
Terrific. So those are the federal rules changes, and now we're going to move to local rule changes. We'll start off with our Director of Operations, Matthew Ritter, to talk about some of those changes.
Well, good morning, everyone. As Judge Claire mentioned, the first local rule change we have is to 1007-5, which regards credit counseling. This change was made to remove the duty placed on the UST's office and case trustee to review the certificate of credit counseling and to file a motion to dismiss if it was deficient. In point of fact, the clerk's office reviews these certificates, ensuring they were taken pre-petition, the debtor's names match what's stated on the petition, etc. And when appropriate, we in the clerk's office will alert the debtor or trustee to any issue or else enter a deficiency order. Moving on to local rule 1040, which pertains to access to filed tax documents. This change was made to remove the U.S. trustee's office and case trustees from the rule requiring the return or destruction of any tax returns or transcripts after review. The United States trustee program has ample guidance in place and properly protects the returns and transcripts. After the change now, you'll note that the rule still applies to creditors and other parties in interest who have been provided these tax documents for review and the proper methods, of course, to destroy them thereafter. Next is concerns Local Rule 2003, which covers our 341 meetings. In addition to the stylistic change, the rule now clarifies the timing for when documents are to be provided to the case trustees prior to the 341 meeting. Specifically note there we have 14 days prior to the 341 meeting. We also changed the verbiage to account for meetings being held remotely, as most are now, as opposed to in person with the switch from bring to provide. And you'll also note a reference to the procedures manual for a list of the minimum documentation to provide in chapter 7 and 13 cases, which we can go and see on pages 20 and 21 of the procedures manual, which we'll cover in greater detail later in the presentation. But you can see there outlined there. Again, those are the minimum requirements. Trustees are able to obviously request more documents if necessary. Lastly, I'll note in your training materials that links to a document on our website on our U.S. trustee and trustee page that contain information about a particular trustee's documentation portal preferences. There are a couple out there, as well as to other acceptable delivery methods. Some trustees would still like to receive these via mail. So again, avail yourself of that document. To move on to the next local rule, I believe Judge Walsh, you want to speak on that?
Certainly. Local Rule 2016-1, everybody's favorite subject, compensation of professionals. But this is just the expense side of things. Rule C refers to the procedures manual for some details about expenses. And so if we go to the procedures manual, we'll then see that we have taken what used to be 2 groupings of expenses and put them in 3 groupings instead. And the basic organization here is there's certain types of expenses that ordinarily will be allowed, certain types of expenses that are not generally allowed, but perhaps in the right circumstances could be allowed, and then certain types of expenses that ordinarily are not allowed. This is the procedures manual. This is not a rule. And of course, all requests remain subject to the actual and necessary standard of Section 330A. So it doesn't matter. It's not conclusive that you spent money on postage. If it was not reasonable or necessary to spend money on postage, you're not going to get reimbursed for the postage. Similarly, for every other category of expenses. And I'm not going to walk through the or by any means any of these in great detail, but the ordinarily not allowed category really falls into 4 buckets of expenses. The first is overhead. The expenses of running your business or your home office are ordinarily not reimbursable. There is a category of pass-through for other professionals. Professionals need to apply for their own fees. They're not expenses of the lawyer. Luxury travel, and then markups. You can't charge the bankruptcy estate more than your actual out-of-pocket expense for a certain type of category or certain category of expenses. So that's a high-level overview of what's in the procedures manual beginning December 1st. If anyone has questions, please feel free to put them in the chat, and we'll see what we can do to answer them when we get to the end of the session today. Next up, I believe, is Chief Judge Claire.
So, Local Rule 3002.1 deals with notices relating to claims secured by a security interest in a debtor's principal residence. This follows on to Federal Rule of Bankruptcy Procedure 3002.1. Most of our changes this year relate to charges for creditors' attorneys' fees. First, we've changed up Section 3002.1 to provide that the limits on fees pertaining to legal services performed by creditors' attorneys or for the benefit of creditors in a Chapter 13 bankruptcy case will be detailed in the procedures manual, and those will apply to notices of fees, expenses, and charges under the rule. Previously, guidelines as to allowed amounts for these charges were listed in, of all things, a November 30th, 2018 Clerk of Court newsletter. This created some issues in that it was difficult for parties to access this and not readily available. We've gone ahead as part of this year's local rule revisions and formalized these amounts by adding them to the procedures manual, where now they're located on, and in the materials you have, those are located on page 23 of the manual. Effective, therefore, for notices, motions, and requests for fees of this type on or after 12/1/2023, creditors' attorneys, and we'll get to this in a moment, debtors' attorneys should look at this information for presumptively allowable charges. The local rule signposts where to get this information, and the procedures manual sets out these amounts. These amounts were determined by the judges after consultation with what we call the Attorney Fee Summit, which was a group of attorneys we pulled together with the Chapter 13 trustee, both creditors and debtors counsel, to discuss the potential amounts for allowance, and they reached an agreement on what the amounts should be in the procedures manual. I want to note, these amounts are limits on fees. That doesn't mean that it's appropriate for every attorney to charge these in every case. If your charges for pursuing a motion for relief from stay are actually less because you're efficient and you normally charge your clients, say, $700, then that may be the appropriate charge. But we wanted to put some presumptive limits out there so that there was clarity and uniformity. To run through these, the first is the charge for reviewing a plan or filing a proof of claim, which we've set at $400. Motions for relief from stay are set at $900, which is above the $700 that the judges presently have been allowing. This applies both to motions for relief from stay on real estate and on motor vehicles. On notices for post-petition fees and notices of payment change, the presumptive charge is $150. This is set up for certain intervals. On the notice of post-petition fees, not more often than once every 180 days, which conforms to the Federal Rule of Bankruptcy Procedure, and on the notice of payment change, not more often than once every 365 days. On notices of default, the presumptive charge is $100, and this is the amount we would expect to see in the Chapter 13 stipulations going forward, and $200 for each appearance at a hearing on a notice of default. To be clear, that's not a potential appearance, that's an actual appearance. And then charges for objections to confirmation will be determined on a case-by-case basis, depending upon the nature and extent of the objection. Starting December 1, $300 per hour is the maximum hourly rate that ordinarily will be allowed to creditors' attorneys who choose to bill hourly. But in all events, hourly rates remain subject to specific objection and, in fact, allowance by any party depending upon the particular circumstances. After some discussion, we are also adjusting the presumptively allowed debtors' attorney fees in Chapter 13 cases for attorneys who bill hourly to $300 per hour. But to be clear, this is the maximum hourly rate. These rates, again, remain subject to specific objection. And in all circumstances, Section 330 of the Bankruptcy Code applies. What Section 330 says on attorneys' fees is that bankruptcy attorneys are entitled to be compensated similarly to non-bankruptcy attorneys. But the rates need to be looked at in this light. If you normally charge clients $200 for services, then adjusting the rate up is not appropriate. That can be brought into consideration if a party objects to fees. I want to note, we did receive information and input from the attorney fee group about adjustments to the currently allowed Chapter 13 flat fee, the initial fee for Chapter 13 fee applications, and on options with regard to those fees. However, those amounts currently are set in our local rules, and changing our local rules is a more difficult process than adjusting our procedures. The judges all intend that when we meet next year to start the local rule process, we will include consideration for adjustments to those flat fees for the next term. If you're interested in having input on those issues, please reach out, as Dana McQuay will tell you at the end of this presentation, to participate in the committee. Our next subject is proof of claim filing provisions in Chapter 11 cases. And I'll turn this over to Mr. Rodman.
Thank you, Judge. As many people will recall on the call, the Small Business Reorganization Act introduced the Subchapter 5 flavor of Chapter 11 case in February 2020. And at that time, we did not have a rules-making cycle, and we wanted to see what would develop in practice before we adopted any specific Subchapter 5 rules into our local rules. Subchapter 5 requires a plan on file within 90 days, but in our district, to have that plan by that time, there needed to be some way to say this is the date that is going to be the claims bar date. There's no, you don't come in and file a motion asking to establish one. There needs to be one, and with enough time to get that plan in order. And so this is something that is spoken about at status hearings. This is something that a date certain is put in any scheduling order in a Subchapter 5 case in this district, but to give ample cover and to make sure that there is no confusion on that fact and when claims are due in a Subchapter 5 case, given that it differs from a standard or small business non-Subchapter 5 case. We have included that 70-day deadline for having that claims bar date for having claims on file in our local rules going forward. So it's going to be in our local rules. It's always 70 days, but make sure you pay attention to what is going to be in the scheduling order for a date certain of when that 70 days is going to be.
And one practice point on that bar date issue, which is customarily the court sends out the 341 meeting notices in a Chapter 11 case. In a Chapter 13 case, what happens is if creditors are added to the matrix later, it may become necessary for the debtor's attorney to give notice of the various deadlines. Chapter 11 attorneys are probably not aware of this need because normally the bar date is set later on. So if you are filing a Subchapter 5 case and you file that case with an incomplete matrix, or you amend your matrix, you are going to have the responsibility to notify creditors. If you have an emergency filing with only 10 creditors and you add 200 creditors, this could be a substantial expense. So it's very important in a Sub 5 case to have your matrix ready at the time you file in order to manage your expenses associated with notice and postage. Judge Walsh?
Yes, next up we have Local Rule 3007. This is a pretty straightforward change. The issue here is that Federal Rule 3007A1 requires 30 days to respond to a claim objection, and our local rule in Chapter 13 only provided for 21 days. So we have made this slight fix to allow 30 days to respond to an objection in Chapter 13. We then made a related change to shorten the time between objection and hearing from 30 days to 21 days, so that depending on when hearing dates are available, the overall time to get a hearing on a claim objection may not be particularly, it may not be longer, could even be shorter, I suppose. There's also a sentence deleted near the end of the rule. To be honest, we read this sentence a few times and scratched our heads and thought, we're not really sure what's going on here. It might be simpler if we just took it out and let parties deal with resolutions and other things in the ordinary fashion. We didn't need to specify that in Local Rule 3007. So that's the nature of the change here. There also will be a corresponding change to Local Form 11 that will adjust the 30 days and the 21 days in line with the rule.
Let me note, in Chapter 13 cases, the lengthening of the period to 30 days means that in most cases, you will not be able to accomplish a claim objection with an order between two dockets. So if you have claims that need to be dealt with in order to reach confirmation or feasibility, you need to look at these issues earlier rather than later.
Good point. Good point. I believe Dana McQuay is up next with Local Rule 3010.
All right, well, very good. Let's talk about 3010. This is another straightforward example, just as Judge Walsh was explaining in the rule before. We added language that authorizes the Chapter 13 trustee to make deposits of unclaimed funds with the court in amounts that are less than $15. We already had this practice happening, but we did not have a rule that allowed for this. And the larger federal rules address the $15 issue, saying that the trustee can only deposit with the court if there is a local rule that permits this practice. So we had a local rule introduced earlier that allowed this. And so this was in 7 cases, but not in 13. So this is really more of a cleanup to make sure that we have that expressly stated that the 13 trustee can do the same as a Chapter 7 trustee and make those deposits with the court. All right, then. Let me move on through. I think Matthew Ritter, perhaps?
Yes, yeah, here to just speak briefly on the change to Local Rule 3015, which covers Chapter 13 plan contents. Minor change, but nonetheless a worthwhile one, which is that we formerly referenced the NADA or Blue Book as the proper source to determine the retail value of vehicles at the time of filing. J.D. Power, who now has bought the NADA, now publishes an official used car guide. We have a central edition that should be consulted when you're doing that valuation. Next, Judge Strath-States will speak with you.
All right, so I'm going to talk about Local Rule 4001-1, which deals with motions for relief from the automatic stay. This rule was amended to account for the 30-day and 60-day grants of relief from the automatic stay if a hearing is set more than 30 days from the filing of the motion, or if a hearing is continued to a date more than 60 days out. Thereby, the movement is waiving their right to have the automatic stay terminated. Section 362 E1 and E2 call for the automatic stay to be lifted if the hearing is not concluded in that time within the 30 days or within the 60 days. So this just clarifies again that parties are waiving that requirement if they agree to a hearing that is more than 30 days out, or if they agree to a continuance that is more than 60 days out. The other rule I'll talk about as well is in 4001-3. That talks about motions for imposition of the stay. So as we know, in 2005, in Congress's infinite wisdom, they gave us this. They kind of made our automatic stay not so automatic anymore. So if the debtor has had 2 cases in the previous 12 months, the automatic stay does not go into place at all. and a motion to impose the stay may be filed. So the rule was amended to clarify that motions to impose the stay do not have to be filed on an emergency basis. Certainly, if you want to file it on an emergency basis, you can. And if you follow Local Rule 9013-2, file a written motion telling us why it should be considered on an expedited basis, and then contact the judge's courtroom deputy to obtain a hearing date, we certainly will hear it on an expedited basis, but it is not required to be filed on an expedited basis. The rule was further amended to require that such motions are to be verified or accompanied by one or more declarations or affidavits that meet the burden of proof in the case, that the case was not filed in bad faith, and also that there has been a substantial change in the financial or personal affairs of the debtor since the dismissal of the most recent previously filed case. So now when you file a motion to impose the stay, we're looking for that motion to either be verified, signed off on by the debtor, or that there are declarations or affidavits that tell us what the reasons are, that the case is not filed in bad faith, and tell us about what the substantial change in the financial or personal affairs that has happened since the last filing. That is what is required by the code, and that is what we will be looking for going forward on those motions. Fortunately for us, we don't see a lot of those motions in this district.
Judge Surratt states, do you look at the certificates of service on these motions to see if service has occurred?
I do myself, and Mr. Howley check those motions as well to make sure that there's been appropriate service to all the parties that would have an interest.
And in my chambers, I review them and Jennifer Haven reviews them. So we look to see if service has been made, not just on the Chapter 13 trustee, but on all creditors, and in particular, if a foreclosure is pending, counsel for the foreclosing party and any trustee. So we will look at those certificates of service. We will let you know if there are problems with those certificates of service. And if you're going to need something on an emergency basis, it's important to have done your due diligence so you have the right parties listed.
Agreed. All right, I think Judge Claire, you're going to talk to us about Rule 9019.
Yes. So for those of you who don't know, we do have a local rule 9019 and it deals with mediation. This is the part where I put in a plug saying if you have a difficult dispute, whether it's a factual issue, a legal issue, or even you're dealing with parties who have personality clashes, we're happy to offer mediation either with one of us, one of our colleagues from the Western District, and in other circumstances, we're even able to go outside the state. So we encourage you to bring matters up for mediation so we can reach a negotiated resolution if that's possible. This year's change is to Local Rule 9019G, which deals with confidentiality. I will note, some parties do choose to enter into a mediation confidentiality agreement, and our rule does not prevent the parties from entering into an agreement of their own devising. However, even when there's not an agreement, Local Rule 9019 provides confidentiality for conduct or statements during the mediation. Previously, that rule used the language in the course of mediation, but we made the change just to clarify and to use more concise language for the reader. We'll talk a little bit later in the presentation about the upcoming restyling of the Federal Rules of Bankruptcy Procedure, and we've been taking steps the last 2 years to try to bring our local rules closer to that restyling as we go. The next rule is a rule that is near and dear to everyone's heart. Local Rule 9050 deals with proposed orders. We've made changes to one section of the rule, which deals with the time of submission for these orders, but this is also a good time to review some of the requirements. First, the changes. Normally, proposed orders should be submitted when the motion is filed, except if the movant is a trustee, and now we've added the United States Trustee's Office, or if there's negative notice. So if you have filed a motion, please send your order at the time in most cases. Next, if there's no agreement on the order, Then we have a procedure for that dispute. The procedure requires the party proposing the order, the party that is the proponent of the order, to do a letter to the court and to email a copy to the opposing counsel, advising the court of the lack of agreement and giving the opposing counsel 72 hours to complete and submit a competing order. The change to the rule was to eliminate language permitting these orders to be faxed. At this point, all of our counsel are on ECF and should be able to electronically transmit documents, and to clarify that it's 72 hours. Finally, proposed orders should not be filed on the docket, even as an attachment, unless the court has directed that that occur, or if a federal rule requires that those orders be submitted as part of a docketed paper. The classic example of this would be under Federal Rule of Bankruptcy Procedure 4001 B1, which requires submission of a cash collateral order as part of a motion. Proposed orders are something that comes up every year. We do monitor these orders as they come in. We do note if there are issues with them. Please make sure if you've done negative notice that you've included a certification of no response. And keep in mind that any order submitted to the court is a representation by the party tendering it, that the order has been circulated to anyone who appeared at the hearing, and that there's no objections to the content of the order. Finally, a note, I know we've all been going through our dockets. If we have instances where orders have not been submitted, and after multiple contacts from our team, the orders do not come in, we will deny the motion for failure to submit an order. Please, we will give multiple opportunities, but we'd rather enter an order and have a matter disposed than trouble you to refile a matter.
Right. Likewise, in my court, sometimes I don't deny the order, but deny the motion, but we'll reset it for hearing again as well and require the parties to all appear again if it was announced that the matter was settled. And let me just reiterate what Judge Claire said about if there is a dispute about the orders, or if you're getting no response from your opposing counsel, feel free to go ahead and submit that order with the letter in the email, just indicating that I've sent it to my opposing counsel. I haven't heard anything from them. Copy them. Do not wait, and we will get that order entered promptly if we hear nothing back from your opposing counsel.
Thank you. All right, Judge Walsh, how about negative
Judge
notice?
Claire, real quick, we got a question in the chat, and I don't want it to get lost in the shuffle later on. It was about mediation, circling back to 2019, and if there is a charge and how that process would work for requesting mediation or asking for a little more information about mediation in our district specifically.
Sure. So parties are always welcome to request the ability or a referral to private mediation. The costs associated with that depend upon the mediator you pick. And in those cases, we would ask that you file a motion for an order directing mediation. However, we understand this is bankruptcy court. If your clients had a lot of money to pay for a mediator, they probably wouldn't be here. So the mediation that the courts offer is generally without charge as to the mediator. If parties want to go to mediation, they can put together an agreed motion. And I know each of us have form orders that we use in those situations to direct mediation to go forward. We would ask that if you file it, you make a request of generally who you'd be interested in having mediate. Another judge of this court, a judge from another court, some sort of information like that. You don't necessarily need agreement to go to mediation, particularly in an adversary proceeding. I have received motions for an order directing mediation from just one side. And again, in those cases, we'll have a discussion about who the parties would like to have mediate. Typically, the process involves directing the parties to reach out to a mediator, or the court can make that reach to one of our colleagues. I do note if we're going to have mediation done, say, by someone in the Western District or we've used Judge Grandy across the river in Illinois before. We do need to put, in some cases, an order or other document in place. Sometimes the circuit needs to approve that, which is primarily an administrative matter, but we can make that happen for you. The parties do generally have the option to either mediate live, or I know for some of our Western District colleagues, we've sent matters for virtual mediation that have been very successful. Mediation is a low-cost way to get input on your matter, and frequently it does succeed. Judge Walsh, do you have any thoughts?
I think that, the most important question, the beginning of the question was, is there a charge? And we don't charge you. If we can make it work with our schedules, we don't have conflicts and those sorts of things, we don't charge you. And that's an important factor.
Judge Surratt states?
No, I have nothing else to add, just that we're always glad to mediate each other's cases. Our colleagues in the Western District have mediated matters for us, as well as Judge Grandy over in the Southern District of Illinois. So we are glad to offer that service if people want them with no additional charge for the mediator.
Any other questions, Matt?
Not at this time, Judge. That's the only one that we've received thus far. I anticipate we'll get some more during our Q&A. Thanks.
Yes, please do go ahead and submit questions. Judge Walsh?
Yes, I have two local rule changes to discuss that I hope will not generate any questions because they're very, very straightforward. Local Rule 9061 ties to the change to Local Rule 3007 that I discussed earlier. We're simply moving the time between objection and hearing for a Chapter 13 claim objection from the 30-day category to the 21-day category. So there's an addition and a deletion, and that's what they accomplished. Even more straightforward, Local Rule 9062 is a catalog of matters that the court will ordinarily consider without hearing. And in our review process, we discovered that there were two local rules that said in their text, the court will consider them without hearing, but they weren't listed in Local Rule 9062. So we've added them here as numbers 21 and 22, and that's 362J confirmations and Local Rule 2016-3C pre-confirmation dismissal fees in Chapter 13. So that is not a substantive change whatsoever. That's simply ticking and tying and cross-referencing matters considered without a hearing.
And I do recommend, when we were reviewing these rules, I had opportunity for the first time in a while to look at the list of negative notice matters and matters that can be heard without hearing. I was surprised by some of the things on that list, and I encourage everyone to take a look. Can really speed up your process. So those are our local rules. At this point, we'll turn it over to Matt Rodman to talk a little bit about our local forms and some other resources available to our practitioners.
So everyone should be seeing our website. As Judge Claire had just said, I'm going to review our website and some of the resources we offer, and also the local form section of our website. The court tries to be very attentive to the needs of our practitioners, and so we take any feedback that we get from sessions like this, sessions like our bankruptcy law symposium in September, very seriously. And so a request from our symposium in September was including this type of session and this type of overview in any future seminars, symposiums, and things like that. And so that is where this comes from. I'm going to start with just simply the homepage. There's a lot of information on the homepage without having to go anywhere else. As Judge Claire and Dana had mentioned early on, we're going to have rebroadcasts of this call. And so if anyone was unable to attend today, they should definitely register for one of our rebroadcasts. That's under news and announcements right in the middle of the page, and you don't have to go anywhere else. That's where you're going to get that information. We have information about unclaimed funds. The clerk mentioned that you can get information about unclaimed funds, applying for them, the registry, and searching for those funds. You can get that information just by going to the homepage. Our procedures manual is on the homepage. 341 meetings, hearing dates. Of particular importance to me as kind of my baby here at the court lately, the court recently created a YouTube channel where we are making information like today's seminar available to our practitioners. But we've also put together some information for our pro se litigants to try and distill some more complex topics in bankruptcy and not give legal advice, but try and simplify some things that are otherwise maybe not quite as accessible or digestible for someone who's not legally trained. We have under general information, this is where all of our general orders live. I think Judge Claire is going to talk about our order suspending the signature requirement here in a little bit. Our current order, you're going to find under general information. So a ton of information just on the homepage itself. But I'll also highlight under attorney information, we have an entire list of different training documents that have been put together over the years that we try and make evergreen so that they'll help be informative in years and weeks and a long time to come. We have things about filing errors, subchapter 5 guidance, some information about certificates of service, and just different items that we think as a court over the years would help our practitioners be successful practicing before this court. I will transition to our form section. Our form section, just the landing page here, is going to have any changes or pending changes to bankruptcy forms. We still have an explanation of changes to the Chapter 13 plan that was effective December 1, 2019. But here on the left side, we break out local forms into a list for each specific category of case or chapter of case rather. We also have a link, official forms takes you to the list of official forms that the U.S. courts provide. So it directs you to the U.S. courts website. Just as an overview, I will start and I'll go ahead and click on Chapter 7 forms here. And this is our list of Chapter 7 local forms. As you can see, it's quite expansive. A couple forms that I'll highlight. We have a sample certificate of service. So Judge Claire mentioned that certificate of service is very important. One thing that we will say, we like to have it. Please, please, please. This is not a copy paste. So we have 3 different samples of our sample certificate of service. It has 3 different options to fit your needs. Please don't just copy paste these though, and don't put all 3 on your certificate of service. Choose the one that best suits what it is that you need, and then customize it to meet your needs further. I don't know, judges, if you have anything to add on that particular item, but that is one that we wanted to highlight.
Sure, we always want to remind counsel that we need you to tell us how people were served. They were served by, ECF, or served by you placing it in the mail to them directly. So I think the certificate of service calls for that information to be readily available so that we know how service was made.
My ad would be, just as Mr. Rodman said, you need to look at the language critically and make sure it applies to your particular situation. Note that while service can be made via ECF, we do need to know who exactly was served. And you can go within the utilities section of ECF for information on where the document will be going so that you can put your certificate of service together correctly. If items are being served by mail, please be specific. Who was it sent to? At what address? And this is something we see, or I see, that happens. Sometimes ECF happens one day and mail happens the next. In that case, you may need 2 certificates of service or a certificate of service that is not included in your document. Please don't make us have to call you and say it looks like you didn't serve and fill in the blank. You may have done it and just not included it. So a little bit of attention to your certificate of service can save you a lot of time. I would also note on our form certificate of service, Roman 3 on the screen share that Mr. Rodman has up deals with service on insured depository institutions pursuant to Federal Rule of Bankruptcy Procedure 7004H. This comes up not only in adversary proceedings, but also on claims objections and motions to avoid lien. You can obtain information about entities online for free. We talked about this last year, in some cases through through Edgar, which is the SEC site, and also through applicable Secretary of State sites. This is the most common error I see is, for example, in student loan non-dischargeability actions or actions involving the United States, is that service doesn't go to the right place. Please take a minute, check it out on the front end. Judge Walsh, anything to add?
I was going to comment on Roman numeral 3 here as well. The insured depository institution is probably the most common omission I see. I think the very first order I entered after taking the oath of office was denying a motion for failing to serve an insured depository institution by certified mail. Very exciting.
What else can you tell us about forms, Matt?
All right, and so everyone should be back to seeing our list of Chapter 7 local forms. Another one that we wanted to highlight, our forms are intended to make life a little bit easier for the practitioner, but also create a standard within our court so that our judges can see the same types of things where it's appropriate. And so wanted to highlight the motion to avoid judicial lien. We also have a corresponding certification of no response in order regarding the motion to avoid judicial lien. Everybody should now be seeing our motion to avoid judicial lien. And as you can see, all that red text is where we've identified that you can customize this motion, this document, to make it your own and add dollar amounts, and just to create some uniformity within our district. This was created with the guidance of our judges. I don't know if they would like to say anything about this form or not, but this is another form that we wanted to highlight just as an example of the types of forms that we have, and the intent behind them.
Judge Walsh?
I will just say that if you use this form, it is much easier for us to digest what is going on and figure out whether your motion is well taken. If you create your own motion to avoid judicial lien, you may get there, but the road is going to be a little rockier. It's just very difficult frequently to tell what is going on if you have your own custom motion to avoid judicial lien.
Yes, I would agree. As Mr. Robbins said, it gives us the information that we need where it is so we can know all the information is there. I usually go straight to the chart that lists the lien and the other liens and what the exemptions are and all that as my starting point when I review proposed orders on that to make sure that the motion is well taken and should be granted.
I have two practice tips. First, note in particular paragraph 4 of the motion, and there's similar language in the order. For those of you who aren't very familiar with Missouri state law practice, while a judgment above $25,000 automatically becomes a lien on a debtor's property located in that county, judgments taken in associate circuit court below that amount have to be, or actually circuit court judgments below 25,000 in some cases, have to be transcribed. This process involves the creditor ordering a transcript and then entering it into the record of the court. In that case, and only in that case, paragraph 4 applies. So you will need to look and see where the transcript of judgment has been filed. I will note this is not standardized in Missouri counties. I wish it was. In some counties, that transcript will be filed in the same exact matter as that where the judgment was originally taken. But in some Missouri counties, a new miscellaneous matter will be opened with a different case number that has that transcript in it. And in that case, you do want to specify both the original judgment and the transcribed judgment. The good news is all of this information should be available to you for free on Missouri CaseNet. So please take a look at that. My second practice point has to do with the chart, but does tie into the various liens. Particularly in a Chapter 13 case where creditors have filed claims, we look during the review of these matters at the actual claims to determine what the amount of other liens are. And if there is no correspondence, we will make a correction or ask you to make a correction. So we will look to see what the other liens are on the property. Moreover, we do check to see if the value of the land listed in the motion matches up to the value listed in the schedules. So when you're preparing your motion, please take a look at the claims register, take a look at your schedules, make sure the numbers match. Thanks, Matt.
Thank you, Judge. All right, and we are back on our list of forms. That's what everyone should be seeing. So as I mentioned on the back end, after you filed your motion to avoid judicial lien, we do have a certification of no response and order on a motion to avoid judicial lien. So that is available to you as well, in the same spirit as having that form motion. It allows our judges to see the information that they need. And see it where they're expecting to see it for a quick review. I will mention a couple changes that we've made, just some cleanup. We removed the exhibit summary. That's not something that's required, and so we went ahead and removed that. We added for use, there might be an occasion to need a bill of costs in adversary proceedings. So we did add that as a new form. That's going to show up on the Chapter 7 list of local forms, but then on also all the other chapters of cases as well. And on the Chapter 13 list of local forms, we've also added a certification of no response and an order regarding applications for compensation that can be used. So this is just a 30,000-foot view of all the forms that we offer. There are Chapter 11 forms as well, to the extent that those are needing to be accessed. And as Judge Walsh had mentioned when we reviewed our changes to the local rules, there will be a change to local form 11 to account for some changing deadlines. That will be posted in the appropriate places as of December 1, 2023, when our local rules changed. I do quickly want to also highlight our kind of don't have an attorney section, just for those who may find it useful. Particularly are representing yourself in bankruptcy tab amongst the don't have an attorney section. This is a list of handouts that we have created for our pro se litigants in the same spirit as I mentioned those YouTube videos that we created. These are quick one-page handouts that are going to try and help distill some complex legal concepts into a digestible way, but stopping well short of providing any sort of legal advice or telling our pro se litigants what to do. Along those lines as well, I do want to take a quick moment to highlight our pro se assistance program that the St. Louis pro se assistance program, that BAMSL operates, and the court definitely supports and wants to promote. If you have any interest in participating in our clinic, there's a pre-filing clinic where attorneys answer any questions for potential debtors, and then a post-filing clinic where attorneys answer some questions for some debtors who have already filed a case and have run upon issues in that case in 30-minute meetings. Please let me, Matthew Ritter, any of the judges, the clerk know. We can get you in contact with the folks at BAMSL, with the individual attorneys who serve on the Pro Se Assistance Program Committee. It's a very worthwhile endeavor, very fulfilling, rewarding, and there is a referral service at the end of the process with that potential debtor or current debtor, where they're given a list of names that they could choose to contact if they need further help, further questions answered, further representation. So just want to take a moment to highlight the work that they're doing, and mention that you should contact us if you want to get involved. That is kind of all I have on the website, unless Dana,
I'd be-
Matthew, and of our judges would like
Yeah.
anything else highlighted.
I'd be glad to give a thumbs up to the Pro Se Assistance Program as well. I participated in it for a number of years. It's very important. It's very it's rewarding, and an important thing to consider if you come from a practice that is not primarily a consumer practice, like I did. We're not just going to throw you to the wolves. You will get training. You will know what you need to do before you're on the phone with a pro se debtor or potential debtor and trying to figure out what's going on.
Right. I would also second that. I think that we, of course, all owe a duty to do some pro bono work. We're not trying to take work away from our debtors counsel, but there are just some people who aren't going to hire a lawyer or are very nervous about hiring a lawyer. And I think this service is very good, that offers an opportunity. I think all the information that we have, ultimately, we're always trying to encourage potential debtors that they should not proceed pro se in bankruptcy. And we do have an opportunity to make referrals to them, debtors counsel, if they so wish. But I think it is important that we have this information out there for them. And hopefully for a lot of the pro ses, I hope that they realize that this is a difficult legal process and they should obtain counsel. But it is important that we provide this information, and the Pro Se Assistance Program has worked very well. We appreciate all the lawyers who have volunteered their time, and hope that we will get more of you to volunteer with that program as well.
And as someone who did do time volunteering, did spend time volunteering with the Pro Se Assistance Program, we are pleased to let everyone know that even though we seem to be exiting the COVID situation, one of the positive outcomes is that now attorneys who volunteer for the Pro Se Assistance Program are able to provide that service to pro se debtors virtually, which makes it a lot easier. When I did it, when Judge Walsh did it to a large degree, we had to come down to the court and sit. And if someone didn't show up, then you were sitting in a room. Now it's done virtually by telephone, or in some cases by video conference. It makes it much easier and you lose less time in terms of administration. So there's many opportunities. We encourage you all to reach out, especially this is the week after National Pro Bono Week.
Right. And for those, I'll just add as well. And if you are doing it by phone, BAMSL has software available so that your actual telephone number is not appearing. So you will not have some pro se debtor calling you all the time. They have technology set up so that that information is not given out.
So these were the main items on our, please go ahead.
I was just going to ask if the clerk had anything to add, and then we could move
I,
on. So I
I
think
echo what everyone has said before, particularly Judge Surratt States saying about litigants. There are people who are determined for reasons that are specific to them that they want to proceed pro se. And sometimes that comes back to hurt them in the sense that they have some unexpected problem with their case and they don't know what to do. And this is where the Pro Se Assistance Program assists them to kind of outline what might be a choice. And sometimes they do follow through and hire counsel. The program that is pre-filing, similarly, many of those people are learning that indeed this is a difficult area of law. Navigating on your own is not easy, and maybe it is the best thing to get a lawyer. And so I think that we have benefited all around. The community gets this benefit, our pro se litigants who may become represented get benefits, or if they continue pro se, they may get some reason to contact an attorney. There's just a lot of positives all the way through. So it's a good program, and we encourage everyone to consider it. It's time now. Maybe we should turn our attention to our judges panel here. Matt Rodman, I think we have a question in the chat.
I'll go ahead and read just word for word. It happens to somewhat lengthy, but it circles back to our motions to avoid lien highlight that we just did. So going back to motions to avoid judicial liens, circuit court judgments are automatically liens on real property in the county in which the judgment was entered. Associate circuit court judgments must be transcribed. Oftentimes, after a bankruptcy is closed and a discharge is entered, a client will want to sell their real estate. The title company will show a lien on the property even though that judgment happened in associate circuit court and was not transcribed. I have found that the rules are what the title companies say they are. Would the court entertain a motion to avoid judicial lien that is just a judgment in associate circuit court?
Yeah, I think we would. Certainly, I don't recall what court the judgment was in, but certainly I have seen motions to avoid a lien after the discharge order has been entered in a similar situation. So yes, I think we would consider it.
Yeah, I don't think we have any way to know the exact status of that lien that you mentioned in your motion. It may have been satisfied, for example, and we don't know. So we're going to get the motion that says there's a lien, the numbers work out, everybody's been served properly, everything else lines up, no one objects, and you may very well get an order avoiding a lien that isn't a lien for one reason or another, and that's I don't see an issue with that.
I have in fact litigated this issue when I was in practice. A couple notes. First of all, this often comes up long after the case has closed, and you may need to reopen the case in order to make this happen, which is an additional charge that's associated with it. Second point is you will need to figure out the property value as of the petition date. And I did have a case where that was an issue, and I had to obtain an appraiser to come in and testify, actually to provide an appraisal, and then we presented an offer of proof about what the value of the property was some period of time before. And then you will have to document what the issue is in terms of there's something out that is showing as a lien. We're not necessarily sure that this is in compliance with law, but we're satisfying the title company, which shows it on the report. Let me note, each of these situations is different. The exact facts will determine your outcome. And it's important, if you can, to evaluate some of these lien issues during the case as opposed to later on, to save your client the trouble of having to reopen. And let me assure you, having had to get a valuation of real estate a number of years later, I won't say what that number was, it's much easier to do it during the case. And also, you should be able to get this information now through CaseNet for free, which is every bankruptcy lawyer's favorite price.
I see a question in the chat. It says, this is going back to proposed orders. If the orders are to be filed at the time the motion is filed, how are we to circulate the order? Did I misunderstand? I am doing this and working on something at the same time. Can you clarify?
Lawyers multitasking. Yeah. So when the case, it is correct. When the motion is filed, you are supposed to file a proposed order at that time, and our courtroom deputies hold on to those orders. If later on and the hearing is held and there is a different disposition than what was in your original order because there were other parties there, that is when you need to circulate it. If you show up and nobody's there, or there's some objection that's overruled, and the proposed order that you initially submitted along when you file the motion can be entered, then we'll enter that proposed order.
And I would note, I would say in well north of 80% of the cases, the order that's initially submitted turns out to be the order that gets entered. Judge Walsh, anything to add?
That makes sense. I mean, one of the things that the submission of an order with the motion facilitates is dealing with defaulted motions. It's very, very straightforward for us to get those moved through if we already have the order and don't have to reach out and say, where's your order?
Are there other questions?
Matt, I am not seeing that. Are you by chance?
I am not right now. I just asked everyone to put any questions they may have for our judges in the chat. We did talk about a lot of rule changes and form changes, though. But are there going to be? Is there any fee issues or fee increases on the horizon?
So Matt, actually, if we could, we have one other change to the procedures manual.
Right, I forgot. I was supposed to talk about this. The meeting of creditors and trustee information, the required documents that the Chapter 7 trustees are looking for has been included now in the procedures manual. So it talks about the required documents that our Chapter 7 trustees require. First, initially, pro se debtors need to have a statement under penalty of perjury. All debtors need to have a valid government issued photo ID and proof of their social security number. The trustee is also looking for the most recently filed federal and state tax returns, pay advices for the 60 days prior to filing. They're looking for savings, checking, and online account statements that show the amount at the time the case was filed. That includes things such as PayPal, Green Dot, Cash App, Venmo, Zelle, etc., because it seems there's an ever encompassing list of those types of documents, and then divorce decrees or separation agreements that were entered within 1 year of the petition date. Now, this is not an exhaustive list. I know some of our Chapter 7 trustees are looking for other things as well, but this certainly gives us a general idea of what they're, at a minimum, what they would require. It likewise then goes on to say in Chapter 13 cases, debtors are to provide similar documents to the trustee 14 days prior to the 341 meeting. Again, pro se debtors have this statement under penalty of perjury. Again, looking for a valid government issued photo ID and proof of social security number, most recently filed federal and state tax returns, pay advices 60 days before. The Chapter 13 trustee has a questionnaire sheet, and we have a link in there that will take you to the Chapter 13 trustees website so that you could get that. And again, we said the lists are not exhaustive. The trustees could ask for some additional documents. While we're here on this, some of you may have been in my docket yesterday at the end. Let's talk about these tax returns for a minute. We know that the Chapter 13 trustee is required to know that the most recent tax returns were filed. It comes up as an objection to confirmation much too regularly. We also see motions to dismiss filed by the Missouri Department of Revenue mostly, but also sometimes filed by the Internal Revenue Service. So I would again remind counsel, and we know debtors are not easy to work with all the time, and we're asking them for a lot of information, but we know tax returns is one of the issues that is definitely going to come up, particularly in the Chapter 13 cases for confirmation. If you know your debtor doesn't have tax returns, try to get them started on that early. But to ask about that in advance. I did mention that we had a meeting with the judges over in the Western District of Missouri, and they do a different process with the Missouri Department of Revenue. If the Missouri Department of Revenue files a motion to dismiss the case for failure to file tax returns, there's a notice that goes out, and it is 45 days to get them filed. And if the Department of Revenue gets them, they file, well, I'm sorry, debtors council has to file some certification that they got them and served them, and then the Missouri Department of Revenue would withdraw the motion, and it is never set for hearing. So that's something that we are considering. So I would again strongly encourage debtors council to continue to work diligently to make sure that your clients have these tax returns, because as I indicated, we know it's going to be an issue.
I think a lot of people know we had special tax return dockets this spring. Both Judge Surratt States and I, each of us had somewhere north of 700 motions for tax returns. We are hoping not to repeat that. But one of the side effects of those motions is now we are seeing the trustee's office file motions to compel turnover. You know they're coming. Please be prepared, warn your clients, and if you can, amend your plan early. All right.
I
The
did
other
get a couple.
topic,
I did get a couple more questions if we'd like to.
let's have them.
Yeah. So the first one is about certificates of service. And this person writes, sometimes I work late into the evening and want to file my document and put the certificate of service date on the date that I filed it, but I know I need to mail out the document for service the next day. Do I file a separate certificate of service stating the date as the next day, or just put the next day on the certificate of service when I file? I feel uncomfortable stating I mailed the notices when the date hasn't come yet.
I feel uncomfortable with that too. I would recommend that you certify that you have served a document after you have served it. So if it's necessary to file a certificate of service the next day after you've dropped the document in the mail, I think that's preferable.
I think you need to be accurate. So if electronic service is happening on one day, then the certificate of service can reflect that, and you can file a supplemental or amended certificate of service the next day. Truth is what we're all about here.
Perfect. And then the next one deals with debtors having how debtors' attorneys have been handling getting cars repoed prior to a Chapter 13 being filed. And the question was, are debtors just giving the cars back, or have creditors' attorneys been filing motions or adversaries for turnover of the vehicles?
I haven't really seen that issue come up.
I mean, I think we're very fortunate here that our debtors bar and our creditors bar really do have superior communication. And in these situations, I think a lot happens informally. What we can tell you is there is a federal rule of bankruptcy procedure change coming that will go into effect, assuming it's approved, a year from this December 1, so December 1, 2024, that permits a motion for turnover to be filed as, in fact, or a request for turnover to be filed as a motion as opposed to an adversary proceeding. But I think I speak for all of us when we'll all entertain, if an adversary is filed, a motion on an expedited basis.
Right. And likewise, as Judge Shermer did, he and I did when he was here. If a motion for turnover is filed regarding a car, if the creditor doesn't object, I will entertain that as well.
Yeah, I don't think I've seen an adversary in this context, but if it's, I agree, if there's an urgent situation, it needs to be dealt with quickly, we'll get it set and we'll figure out what to do.
And that was all the questions that we had in the chat. I'm not sure if there's any other topics the judges would like to consider before we start wrapping up.
I vote we turn it over to our clerk of court to talk to us a little bit about a preview of what's coming next year. It's a big year next year.
And it is a big year. Thank you for that, all of you. One of the rules is 7001, and that's the reference that Judge Claire made about the Bankruptcy Rules Committee responding to City of Chicago versus Fulton. You remember that case about the repossession of a vehicle and how can that vehicle be obtained so that an individual under 13 can go to work and then earn the funds that would support the plan. So what will be happening is that 7001 will be adjusted according to the way that Judge Claire mentioned. One of the big things you're going to see is going to be rules changed being restyled. And what they mean by that is they're looking at a couple of mindsets, approaches to making the rules understandable. So I have on the screen here 2 examples, and we'll have this up on the court's website. But this is an example 3002-1 and how it looks today and how it will look in a year from now. So this is again December 1, 2024. The substantive content is not intended to change. The idea here is to make it more readable, to make it very clear and understandable that there are multiple parts to a particular rule because they are set out physically in such a manner to bring your eye, the reader's attention to that. So it shouldn't be something where you're seeing substantive law change. The second example I bring up for you too is about filing proofs of claim. And you will see this is very similar. The substance really isn't different, but the layout is different. There are small details that have been changed, but again, we're not talking about substance, we're talking about form. The entire sets of rules have been restyled. And if you are practicing in other parts beyond bankruptcy, you've seen this in the federal system. The appellate rules, the Civ Pro rules, Crim Pro rules, evidence rules, all have been restyled. It's now bankruptcy's rules turn to have that restyling. So in 2024, we will have a whole series of those restylings come into play. And for each of the next 2 years beyond that, we'll have another series of rules coming into play. One of the other things you might see with regard to the restyling is that the Rules Committee is doing its best to remove the word shall from the rules. And depending on what they have submitted as the substitute, you as a practitioner want to look at that. So it could be that the word shall is replaced with must, but it might be replaced with may, or it might be replaced with should. Now that could very well be a substantive change in terms of whether you must do something or you may do something. And we'll have to look at that as these rules change, but that is one of their objectives, to look at that rule shall and remove that from the rules as a body and then make the substitutes so that it is very clear whether somebody must do something or they may do something or they should do something. So those are the rules that are coming up. We do have some federal rules coming next year. One of them, just as a preview, has to do with the certificate of credit counseling that comes up at the beginning of the case. Right now you have 2 forms, the certificate itself and a form saying, hey, I took the course. So this will eliminate that form that says I took the course. And there will be all these conforming changes because the rule currently talks about a statement, not a certificate. So those changes will be made to that. And then there'll be a rule change in the new year. This is something that is just to make conforming. The federal appellate rules have had this, Civ Pro has had this for quite some time, but we have not had that in the bankruptcy world, and that has to do with substitution of parties. Unfortunately, people have died, and so we have to worry about, is there a party who substitutes? What about a government entity who is sued in their capacity as a government entity and the named government official has changed office? So how do we substitute? We have taken those on, just as a regular routine business, but we never really had a federal rule that guided us. We just provided some guidance from the other federal rules, but this will be coming forward in the new year. So we'll be on the watch for that. Let me move on to talking a little bit about the Rules Advisory Committee that was referenced by both our judges and Matt Rodman. We cannot thank enough all of the people who work on that. It is loads of work in the sense of intellectual work. It's not so much in terms of the hours and time, but you have to think through the rules. And sometimes, as you know from your practice, one rule relates to another rule, which has a third rule also involved. So we have to intellectually go through that. And that is actually satisfying in a lot of ways, but it is something that we have really applauded our local rules advisory group for doing that work and to spot where a change in one local rule might affect a change in or needed to be changed in another. So thank you to all of them. And thank you to anyone who may be interested in joining into the Local Rules Advisory Committee next year. At the beginning of the calendar year, we will do a blast to the bar and we will open the window. We'll say, if you're at all interested, please let us know, sign up. Matt Rodman coordinates that. I already have received something from our in chat with the name of a person who is interested, which is great. If you've already told us, you won't have to tell us again, but we will make sure to get people in so that you can do this and take care of it here and all. CLE is provided. That's something that I mentioned at the very beginning of this court, and there is a CLE certificate that is going to be sent out to you. On that certificate, it'll have the ID number for MOBAR CLE, so you can just plug and play and move through with all that you need to register that CLE credit. And then you will also have the benefit of a survey. That's going to come at the end of our program. WebEx will be sending you a survey asking for your input. How did this presentation go? What are your ideas for improving upon what we do? And what are our future subjects? And we take seriously, again, what you have to tell us, and we will consider all of that as we move forward. With that, I think what we will do is I'll open it up to anybody on our panel, anyone in the group, to talk. It says, one more thing to bring to your attention is that the bankruptcy miscellaneous fee schedule on occasion has increases due to inflation, and this year is one of those. That will be effective on 12/1 of 23, and we will post those numbers on our court's website so everybody has that. The fee schedule, when you talk about inflation, we're talking about going up by $1 or maybe at most $7, something along those range. But we want to make sure everybody's available and has that, and they'll be effective on 12/1. With that, let me open it up. Is there anyone else who would like to speak to this before we end? All right, with that, we have an opportunity to thank you. We really appreciate the time that you took to join us for this particular presentation. And for those of you who will be joining us with the rebroadcast, again, we appreciate you took time out of your life and your schedule to join us, and we hope it's been beneficial. We really do take seriously your thoughts, so please give us some contact. Matt Rodman is our point of contact, but any of us would be more than happy to assist where we can. So thank you for our day, and enjoy the rest of today and all of the holiday season. Thank you.